for being late.
That's okay. You were in good company. And Senator Daughtry.
Thank you so much. Apologies for being late. It's that time of session where I feel like we all need to be in 5 places at the same time. But I am Maddie Daughtry. I represent Senate District 24, which are the communities of Brunswick, Hartsel, North Yarmouth, Freeport, and Pownell. I'm honored to be the Senate Chair of this amazing committee. I'll kick it back to you, Mike.
Perfect. All right, Steve, why don't we, Representative Gear, I'm sorry.
That's okay. Thanks. I'm Tracy Gear. I represent House District 9, which is Kennebunkport and Coastal Biddeford and Kennebunk.
Did I forget anybody else? It's what happens when I bounce around. All right, very good. Well, Steve, if we want to open up with one of your choice.
Sure. So the first one that I have for you is LD 225. If you recall, this is the second time that this committee has seen this bill during language review. There were some concerns with the way that it was originally drafted at the last language review. I have since worked with Representative Rader, who is the sponsor, as well as interested parties, including the MEA, the Chamber of Commerce, and others. I believe that all parties are satisfied. And there is no fiscal note, and it was unanimous to pass as amended.
Are there any questions for Steve? Seeing none, roll the next one, Steve.
So the next one that I have is LD 898. The title was changed to an act to create the Essential Support Workforce Advisory Committee. It was sponsored by Representative Fay. It was 7 ought to pass as amended with 5 ought not to pass and 1 person recording an absentee vote. The language is not different than what the committee voted on. There is a fiscal note. The department said that they needed additional resources, and that's what is reflected in the fiscal note. Happy to answer any questions.
And which department does this come out of?
Department of Labor.
Yeah. Okay. Was there a division though that was asking for a person, or where would this land? Do we think? Do we know?
It is housed within the Department of Labor, but it does include people from, I believe, Health and Human Services as well.
Okay, that's what I'm remembering. Yep. Okay, great. Yep, perfect.
If there
are there any? Oh, go ahead, Steve.
Nope.
Are there any questions? All right, looks good.
All right. So the next one that I have is LD 1808. It's an act to address employee retention at the Maine State Police Crime Laboratory and the Computer Crimes Unit within the Department of Public Safety. If you recall, there was a bill last session, LD 1101, that moved civilian employees within the crime lab and computer crimes unit into the 1998 special plan. This bill makes it retroactive so that the employees have their retirement benefits calculated as if for the length of their entire service they were in the 1998 special plan. Otherwise, they're subject to reductions for each year. I think I said it was unanimous, and there is a fiscal note required because of the UAL and ongoing costs.
Okay, are there any questions about the crime lab bill? Seeing none.
Okay, sorry. The next one that I have for you is LD 1879, an act to support law enforcement officers, corrections officers, E911 dispatchers, firefighters, and emergency medical services persons diagnosed with post-traumatic stress disorder. So if you recall, the committee voted to require specific claims data when a new category is added to the presumption. And that includes every 5 years, or excuse me, 5 years after the initial addition of that category, and then 10 years after the addition of that category. It also extends the repeal date from October 1st, 2022 to October 1st, 2025. There's a fiscal note required, just minor cost increase to other special revenue funds in the general fund.
Okay, great. Are there any questions about this one? Another unanimous. We like it.
So the next one that I have for you is LD 1925, which is a resolve regarding legislative review of portions of Chapter 9, rules governing administrative civil money penalties for labor law violations, a major substantive rule of the Department of Labor, Bureau of Labor Standards. So the majority report was ought to pass, but the minority report is this amendment specifying that the department is not authorized to finally adopt provisional rules within Chapter 9.
Okay, so the majority is just what we voted on.
Correct.
Okay. Is the minority report acceptable? I'm seeing nods. All right.
Yes.
All right. Very good.
I think
Yep. Okay.
I thought that this might be something the committee wanted to discuss earlier. I think Representative Sylvester, you had this conversation with me about stripping the emergency on the majority report.
Yeah.
I will say, if I may, so the way major substantive rules work is that because it was filed on time, and if it's because this bill has an emergency preamble and clause, if it fails enactment under the emergency, that would be considered a failure by the legislature to act. So it would actually have the same effect as the majority amendment anyway. So it would allow them to authorize the rules. So
Okay, I haven't had a request to do this. So if the department wants it, we'll do it on the floor. So unless anyone else in the majority has an objection with that. Okay, all right, we'll go ahead and do that.
Okay. Let me share my screen. The next one is LD 1966, sponsored by, I believe it was Senator Curry, an act to facilitate access to heating assistance. This was 12 ought to pass as amended, with one person absent at the time of the vote. All this bill does is it adds an emergency preamble. And if you recall, this bill requires them to adopt rules to accept online applications for this winter period for home heating assistance.
Okay. Are there any questions? Seeing none.
So this one is LD 1997, an act to implement certain recommendations of the committee to study the feasibility of creating basic income security. It was voted 8 ought to pass as amended, with 4 voting ought not to pass and 1 person absent at the time of the vote. So this establishes the Basic Income Security Committee to study basic income security and to make recommendations back to both the Labor Committee as well as the Health and Human Services Committee, with a reporting date due in December of 2023. So it's a 2-year study. They are authorized to use funds that they have already raised, which is about $19,400. They also have the ability to raise additional funds if the committee finds that's necessary there was discussion about doing a feasibility study. So that would give them that ability.
Okay. And is that the fiscal note?
Yep.
Yep. Okay. All right, great. Is there any questions about this one from the majority? All right, very good. Thank you, Steve.
Sure. So the next one is LD 1724. I have not had this processed by the revisor's office at this point, given the quick turnaround as you worked this bill on Wednesday. So this was President Jackson's bill, an act to create a logging dispute resolution board and to require proof of ownership documents to be available within 14 days of request. So the amendment sort of clarifies the issues that were raised at the public hearing, and I think capture what Representative Sylvester raised in his bulleted list when the vote was taken on Wednesday. So it lays out compensation of members, whether the decision of the board can be appealed to Superior Court. It also specifies that the Board of Arbitration and Conciliation shall enforce it within existing resources. It also defines forest products harvester to mean an independent contractor that is engaged in harvesting trees from forest land for a forest landowner. And it specifies that forest landowners are persons that own or possess economic control over more than 50,000 acres of forest land. It also specifies that the board can conduct rulemaking, and specifies that a complaint by one of the parties to this board may not be filed more than 2 calendar years after the alleged dispute. The only question I have for the committee in terms of how this proceeds is this is one section of LD 1724 as it was presented. I don't know, there was discussion about stripping the cabotage part, and I don't know where the committee landed on that. So as it's written, I have kept that in, but I'm looking for guidance from the committee as to whether that section is also stripped from this bill.
Steve, I've had a couple requests. If you could send this to us, and we're going to take it up after the 1 o'clock so people get a chance to peek at it.
Okay.
So we'll take this up after our 1 o'clock session.
Okay.
Representative Cuddy, did you have a question before we?
I just wanted to respond to Steve's question about the cabotage. My understanding was that we were going to leave that in because we discussed severability as an issue at committee. So if the cabotage part is found, which I don't think it will be, but if it is found to be unconstitutional or problematic and is struck down, the rest of the law would survive. So I'm fine with leaving it in because I think it's perfectly legal anyway.
That was the discussion. But all right, so we're going to have this sent out and we'll take it up at the end.
Sure.
Great, thank you, Steve.
Yeah. So the next one that I have for you is a little tricky. So if you recall, I think it was a month or two ago now, the committee voted on LD 1840. So LD 1840 makes it so that certain employees in the Department of Corrections are retroactive. So it treats them as if they have been in the 1998 special plan for the whole duration of their service. But there was questions about the bill as drafted. So the bill as drafted says that in order to qualify for this retroactivity, the qualified member has to have been employed by DOC prior to January 1st of 2000. And they have to be employed as a supervisor of correctional officers in a correctional facility. So I believe Jeff McCabe and Miss Morin from Maine PERS, as well as agencies, including the Department of Corrections, provided input on what that entails. So the direction that I need from the committee is there are a lot of job titles on this list that's in front of you. And it's not clear what their duties are, but for the purposes of ensuring that these people are included in the committee's vote, are there any names or positions that you would wish to exclude from that category? Because the category is broad. It just says they have to be a supervisor of correctional officers in a correctional facility.
Mhm.
But the titles here vary from correctional captains to unit managers, to lieutenants, to operations supervisors, to unit managers. So
Yeah,
in
there's a
order,
lot of folks on there.
yeah,
Uh,
so in order for this to move forward, it needs to be explicitly stated what the committee's intent is in terms of how do we narrow down who qualifies as a supervisor of correctional officers in a correctional facility. So I'm going
Okay.
to leave this list
Yeah.
up for you.
Yeah, please leave the list. Ms. Moran, if you could come on camera, that'd be great.
Quick question, Mr.
Yep.
Chair. Anytime we post names up, especially when we're streaming, I get nervous. I am assuming it's acceptable that we have state
It's
employees'
public
names.
information. Yeah, you can
Okay.
get names. You just can't get anything else.
Okay, thank you.
Yeah, you're welcome. Is Director Moran? Am I just missing?
I'm here.
Oh, hi, there you are. Welcome.
Thank you.
So I wonder if you could just walk us through a little bit about how this list was generated and what it represents to you.
Okay, so we reached out to the fiscal office. We reached out to Mr. McCabe at MSCA. I believe he reached out to DOC. So each of those entities provided to us various lists. We started out with multiple lists, and we've worked with the department and with Mr. McCabe trying to get the list to be a point that people agreed upon in terms of who should be on this list. My understanding, this is the last list that came from Mr. McCabe, and I'm not sure whether it came just from his sources or whether it was compiled in conjunction with DOC. But my understanding is that the people on this list are the people who are currently within the supervisory bargaining unit with MSCA. So at least from that perspective, there's some supervisory responsibility in the list. We don't know for these positions, we don't know whether these positions all supervise corrections officers as the way the law is currently drafted. That would be something that I don't know if Mr. McCabe is on this meeting or not. I don't know if he knows that or whether the department needs to weigh in on that. But we certainly don't look behind and have job descriptions that help guide us in terms of establishing whether they meet the law as drafted. So we basically took the list and we have costing information for everybody on this list. And if you include everybody, we have the cost. If you exclude certain people, we can get to the cost. So it's really a matter of, I think, as Steve said, determining whether everybody who's on this list meets the definition of the bill as drafted, or if you want to exclude people, or if you want to include the group and need to amend the language.
All right, thank you for that. Ms. Moore, are you able to hang tight for a few minutes while we try to raise Mr. McCabe? I don't see him right now.
Absolutely, absolutely.
Justin, would you try to see if Mr. McCabe is available? Justin?
Yes, I will.
Okay, thank you very much. And I will ask my able Senate co-chair to do the same if I could. All right, well, let's push on to the next one for now, Steve.
Sure. So the next one that I have for you is LD 607. So this was by Representative Talbot Ross. It's an act to direct Department of Labor to educate business and nonprofit communities on overtime law. So what this does is it requires the Department of Labor to conduct an educational campaign on overtime laws. And it requires an annual report on those activities to the Committee of Jurisdiction, which would be our committee, beginning February 15th, 2023, and annually thereafter. And it was unanimous ought to pass as amended. A fiscal note is required, but there's a minor cost increase. DOL said that the cost can be absorbed within existing resources.
Okay, great. Are there any questions from the committee? And I wonder if we could flip back to gallery view. There, thank you. Are there any questions from the committee about this one? Unanimous report. Representative Bradstreet.
Yes, I wasn't here for this particular vote. I did vote later on. I guess I just want to make sure that is what the entire committee voted on. It's basically a study, a report, an education.
Yeah, they're going to do a campaign to make
by the department.
Yeah, they're going to do some social media and the stuff they already do to let people know what the overtime laws are.
Okay.
And then, yeah,
I think that's a good idea. Our association actually sponsored one of those a few months ago. We had to pay money for it, so now we should have waited.
no rebates. Yeah, I think we've waded through enough overtime laws and been confused enough ourselves that it's a good idea to get out what the laws actually are to folks. So are there any other questions from the committee? Seeing none.
The next one that I have is LD 463, which was voted on a little over a week ago. So this is a concept draft, but there was discussion about PFAS testing for residents. So I did work with Sarah Woodbury and try to get some more background information, as this area is very new to me and there's a lot currently going on. And I see Senator Daughtry has her hand up. I'm happy to cede to her.
Thank you, Steve. And please go over the amendment. It was actually about a reconsideration. So if you just want to finish what you're switch.
So in working with Sarah Woodbury and actually Senator Hickman, as he sort of had a lot to do with this in terms of the scientific data. So my understanding is that the way that the Department of Environmental Protection is currently doing testing is that individuals can conduct testing on their own under specific criteria, such as they have to use specific accredited labs. They have to report that to the department. They have to meet the maximum contaminant level over what the state established. And they also have to prove causation that the PFAS in their well is related to a sludge or septage site. So what this bill does is it sets up a PFAS fund for providing reimbursement. And it says wells located within a certain number of miles. I think the committee will need to discuss further if that's the approach that they would like to take. The department can use the existing criteria that they already have established, but the reimbursement of the test, so now it's only reimbursed based on if the level of PFAS is over the maximum contaminant level. So what this bill does is says that regardless of what the level is, then the test must be reimbursed to the resident. And it's $1 million fund. You could, I noted at the bottom, you could do something in the Department of Health and Human Services, the CDC's Division of Environment and Community Health. but they don't have established reimbursement programs like the Department of Environmental Protection does. So for drafting purposes, that's sort of where we landed on this. So the clarification that I would like from the committee is whether this captures the committee's intent, but also if it does, what is the threshold of miles or other marker that the committee would like to use in determining who's eligible for reimbursement under this fund that is created.
So this has been changed now to just wells and not soil.
Correct.
The original bill was both.
Correct. If the committee's intent is soil, I'm happy to do that. I don't remember.
I'm pretty sure. Yeah, I don't believe that was changed on the vote. So I think it's soil and water. Does anyone else remember us?
I
Senator Daughtry.
thought this was a water program.
It's going in the arsenic, but that's what I'm asking is I know that the amendment that Senator Hickman was working on the part about the number of miles from the thing, but I'm trying to remember what we voted on. Whether it was to have both soil and water or just water.
Mr. Chair, if I may interject.
Yes, you may.
There's two other bills dealing with the soil portion, and I know this is much larger, but I'm wondering if we might, I mean, I'm happy for it to go to as much as possible considering what a crisis this is, but I'm wondering if it makes sense for us to keep it on water since there's not necessarily another vehicle for that at this time.
Is that the will of the committee and Senator Garin, who's asking us to reconsider? It would make sense to ask everybody.
That's fine with me.
Okay. All right. Yep. Nope. That makes sense to me. I just wanted to make sure we were getting it right. So I know we'd had discussion back and forth. So perfect. Then if we're good on the language, I believe Senator Daughtry has a motion.
I do have a motion. Having voted with the majority on LD 463, I move at this time that we reconsider our actions where we pass this bill.
Is there a second?
Second.
Seconded from Representative Warren. All in favor, and we'll just, if you put your screen on and hold your hand up. Unanimous of those present. Any discussion before we call the roll? Representative Cuddy.
Yeah, we had a discussion with Senator Hickman at one point about some language around using the best science or something in terms of determining this distance. I think that at some point in time, like some hard number had been thrown out, just 20 miles, but we didn't have a basis for that. And the Senator Hickman's idea was to use something along the lines of language that would be distance established by the best science, or that was the direction, so that we wouldn't be prescriptive, but the DEP would, write rules perhaps to figure out how far this program ought to go.
Yeah. Representative Bradstreet, do you have thoughts on
I
that?
recall that as well. I know I asked the question a couple of times about the 20-mile radius, and I thought that was maybe excessive. So I think the senator came up with, I thought, some good terminology to use. Scientifically determined by the best methods available, or something like that.
Yeah, and I was just gonna ask what that language was, because I knew, and I might add, within it already says within a PFAS zone is declared by DEP, but so we just want to make sure we kind of encapsulate all of that. If you're in the zone, or if you're within a distance.
Yes, I could jump in. I think the way that DEP does testing now, and this is obviously not my wheelhouse, but I think they're testing sludge and septage sites, or maybe sludge and someone else might be doing the septage. And then if it's found to be contaminated with PFAS, I think what they do is they go out within like a half a mile radius and start testing wells outside that. So I don't know I think you could just say within a, within a scientific data or something as determined by the department, because it seems like they already have some expertise in doing that, because they're already doing based on sort of where the sludge sites are, is my understanding.
Yep. And the little bit I know about it is they're also using water tables, and, they drag the hydrologist into it in some points to figure out, what are the, where are these wells drawing from? And, so that's something that the hydrologist has done a lot of work on over the last dozen years, is really trying to get water sources mapped. Okay. Are folks comfortable with that language, the way that it's drawn up? So we'll take out the number of miles and put in best science. All right. Then I would accept a motion at this time. Senator Daughtry.
Thank you, Mr. Chair. I move ought to pass as amended on LD 463.
Second.
There's a second from Senator Garin. Is there any other discussion? Justin, if you could call the roll.
Senator Daughtry.
Yay.
Senator Daughtry, yay. Senator Garin.
Yay.
Senator Garin, yay. Senator Hickman's absent. Representative Sylvester.
Yay.
Representative Sylvester, yay. Representative Bradstreet.
Yes.
Representative Bradstreet, yes. Representative Cuddy.
Yes.
Representative Cuddy's yes. Representative Drinkwater's absent. Representative Gear.
Yes.
Representative Gears, yes. Representative Morris.
Yes.
Representative Morris, yes. Representative Pebworth.
Yes.
Representative Pebworth is yes. Representative Prescott is absent. Representative Rader.
Yes.
Representative Rader is yes. Representative Warren.
Representative Warren.
Yes.
Representative Warren is yes. So we have 10 in favor, 3 absent.
The motion being carried 10 in favor, unanimous of all those present, 3 absent. The motion carries. I believe we have Mr. McCabe in our little room. Steve, could you put the list back up?
Mhm.
Welcome, Mr. McCabe.
Good afternoon.
All right, so we were looking at this list. The bill classifies, a little different than the other bill, classifies that there must be supervisors within the correctional facilities. And so if you could tell us a little bit about how we landed on this list.
Yeah, thank you, Mr. Chairman. So for folks, Jeff McCabe, I serve as the Legislative and Political Director for Maine Service Employees Association. I will sort of enter this conversation just by saying these specific retirement issues are tough and challenging to deal with because often they're focused at a limited population, and often we, as well as others involved, I think, are concerned about leaving folks out. At the same time, we want to get these as descriptive as possible so the folks that have to implement these changes in statute can actually do that with as clear guidance as possible. So what you have before you is a list that came through work that MSCA did with Maine PERS, as well as Department of Corrections. And by Department of Corrections, I do believe we're probably talking about the service center, who would have information of active employees, as well as those folks that, and by active employees, those folks that are still working in these positions and on the payroll. These are also folks that Maine PERS has information for and can track them in their database. I've said before to the committee, it's challenging for us at MSCA because our data is not the greatest when it comes to employees at the state. Our data gets better when people are full members of MSCA. So some of our data is is slow to be updated and is not always necessarily accurate for job descriptions and promotions. So this list that you have before you and the color coding has gone from the hands of MSCA to the hands of the state to the hands of Maine PERS. And you have before you probably the most accurate list that we could come up with between those three sort of organizations. And with that, I'm happy to take some questions on this. And I will say, you know, I always am concerned we might have left somebody out. We did ask one of our MSCA stewards to take a quick look at this, and that has happened. But I always just get anxious at this phase of these bills.
Thank you. I know that on that list, having worked with this group before, I can verify just about everyone except I'm going to ask a question about the corrections mechanic at the end. I am assuming that the mechanic is a skilled job that supervises maintenance personnel who are in the general unit. Is that's the one I don't know. End of the list, the last, very last.
Yeah, sorry, the list disappeared for me and it's back up again.
Yep.
Well, this is one that was a question. This came out of our steward looked through the list and felt this person was missing. This is a person that it's unclear to me when I look at our database exactly which facility they're associated with. This, I believe, is somebody that was probably working at Down East Correctional Facility and probably was either transferred from that facility over to Charleston, or it's somebody that splits their time between those two facilities. So that was a name that sort of popped, and I'll be honest, we were sort of confused on where that person's job assignment was. And so we added them to the list. And as you can see, they've been highlighted in orange, so they're included in these costs. So I can't necessarily say, you know, if that person's job description and job title has changed to, you know, fit this eligibility set forth in this bill. That was information, the correction maintenance mechanic that we had at MSCA, but that person's job class may have changed to be something else.
Okay. Is Ms. Moran, are you still there?
I am.
So having swept in all the other folks in the previous bill, if it was found that Mr. Beverly was actually in the general unit, he would just be pulled into that, and the costs that I mean, is that rather than
Yeah, I'm not sure what you mean by having swept in all the people in the previous bill.
the other corrections bill that we had that were non-supervisors that we generated that list for?
Right. So you're talking the bill that was enacted last session?
Right, exactly.
So you may recall, I'm not sure if you're getting to the question of whether this ends up picking up all the corrections employees in this situation. Is that where you're going with the question?
That's where I am. Yeah.
Okay, so the answer is absolutely not.
Yeah.
So last session, the bill that was enacted was a very small group also, and they were people who were corrections employees who received direct care stipends. And that's a term that's only used within the AFSCME union people. So there were 20 something or so folks that ended up on that list. This bill sweeps in people who are supervisors of corrections officers only. And so there, again, it's a small group of people who do that. There are many, many, many other corrections employees who likewise have this divided benefit calculation as between regular plan and 1998 special plan service. I think some of those, Mr. McCabe can confirm or not. Many of those people are represented, I think, through MSCA. They may be represented by other groups also. They're not included in either last session's bill or this session's bill. This session's bill is targeted toward this very specific supervisory group.
Okay, and I guess my next question is for Mr. McCabe again. MSCA represents this individual?
That's correct, Chair Sylvester. And it was our intention to try to, you know, include the folks that were directly supervising the folks that got this change last year. We will be back next session with another bill for a broader category of folks as well.
All right, but I may be ghosting the legislature, but I will haunt you if there are additional names added to this group.
Yeah, and it's I appreciate you raising that. I think we've been struggling with this issue. We also recognize that the second year of the session is really focused on sort of emergency legislation, and so we definitely will bring more bills forth. And I should have started in my remarks today by thanking Kathy, who I do really appreciate all of her work, her patience, and her detail too, to every retirement issue, as well as to your analyst as well. This is a lot more technical than my skill set, and the resources we have, are not necessarily retirement resources, our legal minds. So I do appreciate all the work and behind the scenes people have done this session.
Okay, perfect. Representative Bradstreet.
Thank you, Mr. Chair. Although I'm not on the majority report, I would like to find out for future reference. Is there some way that the state gives a final stamp of approval to every person on the list? Who is the official decider here?
It's a darn good question. What I'm assuming is that MSEA represents the supervisory unit within, which is why I asked that question. Otherwise, I believe they would be AFSCME employees or AFSCME members. And so I think you also have the professional unit. Is that correct, Mr. McCabe? Within the corrections?
Yes, you are correct. This one really was sort of focused on the supervisory unit.
Yep.
And there, this gets into much more complicated sort of conversation around recruitment and retention and some other pieces. But to Representative Bradstreet's point, this is a situation where, because retirement benefits are dictated by statute, if we can get these as clear as possible, the process for the decision ends up falling to main PERS. And I think I'm saying this correctly. This is outside of the collective bargaining agreement. So when issues around retirement or eligibility come up, they really get sort of handed to main PERS and to make those decisions for eligibility. So you're making statutory changes, and then main PERS has to, implement those changes in statute. And I think that's why a list is probably the most helpful in these situations.
I was just wondering if there's a policy in how the final lists are determined. That's all. Not only for this particular group, but other group. I see maybe Ms. Moran has an answer for me on that.
Oh, Ms. Moran.
Well, I think that the department definitely needs to weigh in on that. I really actually had a question for Mr. McCabe, if you would let me ask that question directly to him. It stems, I just want to make sure that we're clear. My understanding from our discussions in developing this list is that there are other people who are in the supervisory unit, though, in the supervisory unit, MSEA, that aren't on this particular list because they don't supervise corrections officers. Am I misremembering that? I just don't want to have this definition be that it's everybody in the supervisory unit, if in fact there are a lot of other people in the supervisory unit who do other type of supervision and aren't supposed to be won't end up on this list.
Yes, thank you for that question. Following as sort of the language of this bill is, these are folks that are supervising those folks, the corrections folks that were within the AFSCME unit who already received sort of this benefit. So yes, there are other folks in the supervisory unit that this bill doesn't apply to. So that, yeah.
Okay. All right. I think that I feel comfortable with this list of people, that they are all supervisors, mostly because the National Labor Relations or the Maine Labor Relations Board has at some point decided that these folks belong in the MSEA unit. And so I am fine with it. And for folks in the majority, are folks fine with this list? Are there objections? Seeing none. And Representative Bradstreet, I am going to try to find the answer to your question with more detail. I'll let you know what I find. Thank you, Ms. Moran. Thank you, Mr. McCabe.
Thank you.
All right, it is 1:04. So I am going to turn my gavel over to the good senator.
hot. Seeing that it is 1 o'clock, that is all of our language reviews, right? I'm not magically missing one.
We
Or do you
have one that we're going to do afterwards. I thought that was the end. I
All
was
right,
making little
perfect.
hash marks.
Yep, that's the end.
Very good.
The
But we have,
final-
yeah, and so I'm sorry, Senator, I didn't mean to interrupt you. But there is also another bill that we will need to reconsider at the end, and then we'll look at this other piece of language. So the department bill, Steve,
Yeah.
on? Did we already do that?
1925.
Yeah.
I brought it up and you said that if the department wanted it, then they could strip it on the floor.
Oh, I thought that was from Mike. Oh, okay. All right. We'll look at that one again at the end. Sorry about that. I was thinking it was the other set of rules. Okay. Awesome. I'm stupid. Thank you, Senator.
Not stupid. It's a Friday after a long week for all of us. It's definitely long since past coffee number 5 of the day. With that, just a reminder to the committee that we are going to reopen up as a work session, LD 965. And before I gavel us in, this is part of the racial impact statement pilot program. So we have folks here from the process to present the first sort of impact statement. And as Steve sent out last night, it can be helpful to pull up the memo that we all received to be able to provide feedback on the process for the Ledge Council, so we can sort of really get a really great awareness of how this is working and, you know, what we need to tweak to make it, you know, truly revolutionary and innovative and useful for all of us. I think it's a really great tool. Full disclosure, I did serve on the subcommittee of Ledge Council that worked on this with Representative Talbot Ross, as well as Speaker Fecto. So I'm really excited for this presentation as well. And if you have any questions, definitely let us know. But with that, in the interest of time, I'm going to open the work session on LD 965, and I'm going to pass it over to, is it Mr. Bam? Is that how you say your last name?
Yes, Baum, but Bam is just fine. I get everything, every variation of it.
I feel that I get the same thing in my last name as well, but excited to have you with us, and please take it away.
Well, sure. I don't have much of a presentation, but thank you, Senator, and thank you all for having me here. I'm happy to answer any kinds of questions. Obviously, I teach employment law at the University of Maine School of Law. I've been here for 11 years. I also teach constitutional law. I'm now the academic dean at the law school. And when Sam reached out with some ideas for potential kind of assessment of racial impact statements, I saw this as an interesting one to consider. Obviously, I think all of us have seen kind of debate nationwide around non-disclosure agreements and the use of non-disclosure agreements to silence employees, former employees, prospective employees in cases of discrimination, harassment, retaliation, that has made it difficult for agencies to investigate misconduct and violations of the law, has made it difficult for courts to hear these cases. And this really became prevalent during the kind of the height of the Me Too era, just kind of a few years ago, as we saw powerful individuals who were able to kind of get away with patterns, continuing harassment, discrimination, because a lot of those acts were being concealed, right? And they would engage in the misconduct. The case would settle, often before even being filed or disclosed to the state human rights agency or the EEOC. And nobody would know about it until it happens again. And you just have year after year where discrimination would go on in the workplace, where prospective applicants, employees really had no way to learn about it. And so that's the piece I was asked to kind of write about, to assess whether it has, this legislation has a potential negative racial impact or positive racial impact. As I caveat in my statement, I haven't studied, I haven't looked at the empirical data as to whether or not non-disclosure agreements are used more predominantly or less predominantly in race discrimination claims in Maine and claims brought by historically disadvantaged racial minorities. So I wasn't able to make that kind of conclusion. But I think on the whole, there's pretty good evidence nationwide that these kinds of laws, we were seeing more and more of these laws passed. California was one of the front runners, but now we've seen more and more states pass similar kinds of laws having a positive impact. It allows the EEOC and state human rights agencies to learn more about misconduct going on. You know, our system really relies on those agencies having more data. And without the EEOC and the Maine Human Rights Commission learning about what's going on, it makes it much harder for them to enforce the laws and to identify wrongdoers. So I think we've seen patterns of these kinds of laws having a real positive effect. The one kind of caveat I noted in a footnote, I'm not an economist. I'm playing an armchair economist here. But I, of course, was a defense. When I was in practice, I did a lot of employment law. I was on the defense side. I know there's a value to confidentiality and secrecy for employers. And assuming there's a value, any law that makes it more difficult or makes these clauses less enforceable would presumably be reflected in either the frequency or the number, the value offered to plaintiffs in these cases. But while that's my kind of armchair economic judgment, looking at the data for California, I don't think that's played out. I think because the law still does allow in settlements, non-disclosure or confidentiality agreements, as long as it's initiated by a plaintiff in one of those cases, I'm not sure if the data will actually play out that way, but I did want to note that concern that potentially victims of discrimination harassment might see a decrease in their settlement offers or severance packages if companies feel like those terms are less likely to be approved. So that's kind of my general kind of view on this. I think there's no evidence to have a negative racial impact. I suspect it will have a positive racial impact, but it would require some empirical work to look at Maine specific data to determine whether or not there actually is a positive racial impact.
Thank you so much. Right off the bat, we have a question from Representative Sylvester.
Thank you, Madam Chair. This is a twofer. The first one is did we not use the data because it doesn't exist? And the second one was, since this is one of our first racial impact statements, could you kind of walk through a little generally what your methodology was in terms of approaching it? I mean, obviously, if you had clear data, that would be where you would go first. But just for the future, how you sort of set it up in your mind as you looked at it. This is what I'm going to be looking for.
Yeah, absolutely. And when Sam Warren had reached out about kind of doing this sort of work, I think me and others in the university system made it clear that it would require, doing a true racial impact statement will require quite a bit of empirical work, right? Actually looking at the numbers on the ground. I did not do that. My work really consisted of doing some research into kind of history of confidentiality and non-disclosure provisions throughout the country and the impact that they have had, looking at some articles and scholarship, kind of describing the harms of those kinds of laws, and looking at just some of the very basic work that has been done on the California STAND Act, which was its kind of first version prohibiting non-disclosure agreements in sex discrimination harassment cases, looking at whether or not it had any kind of a negative racial impact. But it was mostly looking at Westlaw and legal scholarship rather than working with the Maine Human Rights Commission and digging in to the data that they have in terms of when these non-disclosure agreements are actually used. And so I think a true racial impact analysis has to have that empirical component. I'm not an empiricist, and I was doing this during the course of the semester, so I didn't have a chance to really dig in and crunch the numbers.
Okay, thank you. Well, the good news is we just passed a bill to get a bunch of data. Thanks.
Best of both worlds. Representative Warren.
Thank you so much. So I had a question about, you mentioned California and some, I guess, other states. And I know you mentioned throughout the report that there's just a limited accessibility of data in Maine, but I'm wondering maybe if you could talk about best practices, just as an academic or researcher, if there's some way that you could talk about how we can compare the impact of similar legislation from other states, because that was maybe in my head something I thought would be more, I guess there'd be more of a point made during your report about that, about how it had been like the impact in other states or impact of almost the opposite legislation in other states, if that makes sense. So could you speak to that? Is there an ethical issue there? Maybe just limitations of, I guess differential diagnosis, or like you can't pinpoint one thing versus another from state to state, but do you have any insight on that or how we go forward being able to use something like the data that we may be able to collect in the future?
Right. Yeah, no, I think it's a good question. I think different states publish different kinds of data, state agencies. What I would want to look to if I had the time and as the next steps would really be looking at comparing how the settlement agreements looked prior to the passage of the law and how they looked afterwards. and whether it's really kind of a change in the amount given in the terms of those settlements. I think it'd be worthwhile to look at exactly when the non-disclosure agreements are allowed, or confidentiality agreements are allowed in those states. So I know in California, I think the law allows non-disclosure agreements to be put in place before a charge is filed. I think the main law doesn't allow for that. So looking at whether some of those variations might change the data, I think that would be really interesting to look at. But like I said, I didn't have a chance to actually pull the numbers from any of the states and see what actually happened on the ground. I looked at articles. So the concern that I raised, for example, I did a little bit of just Westlaw research on whether or not the settlements in California went down after the passage of the Stand Act. And at least the article that I saw said it didn't go down. But again, I didn't go to the underlying data that supports that judgment and what led to them kind of staying the same. And of course, the racial differences in the workforce will differ from state to state, right? So in some states, race discrimination claims are significantly more likely to be brought by historically disadvantaged groups. In other states, that may not be the case, right? And so in Maine, it may not be the case that non-disclosure agreements are used more frequently in race discrimination claims brought by historically disadvantaged groups. And if that's not the case, then this won't have a positive racial impact either, right? If the plaintiffs in these cases are basically representative of the general workforce, then it's no more likely that a non-disclosure agreement would be used in a race discrimination case by an African-American plaintiff than by a Caucasian plaintiff.
Okay, do I have any other questions from the committee? Going once, going twice. Well, I do want to thank you so much for your work on this, and the methodology was really interesting. And I know this is just sort of the beginning, but I think it's a great opportunity, not only for this committee, but for this legislature as a whole. I do want to check in before we wrap things out. Mr. Langland, what is the procedure? I know we have to do the memo, which is separate after we adjourn to go back to Ledge Council. How do we handle, like, what are the required steps as part of the pilot project? I'm a little bit blanking on that.
That's the only requirement as far as the pilot project. If you recall, this bill was voted last session and reported out, and then was tabled on the floor and was re-referred to this committee back in January. So the committee would need to take a vote on the substance of the bill again and report it out. But the report based on the racial impact statement is separate, and that is not due until a certain number of days after the adjournment of the legislature.
Okay, but we do need to reconsider this to move it right back.
Yeah, you don't have to like reconsider, like in terms of it's not a reconsider vote, if that makes sense. Not like we did with 463. You would just make a motion because the bill comes back without any amendments. And my recollection is that last session, this bill was voted ought to pass, and it became ought to pass as amended with a fiscal note incorporated.
Okay, so we just move it like that. Okay, I think I'm all there. Representative Gear and then Representative Sylvester.
Thank you, Madam Chair. Yeah, my question, I'm not sure who can help with this, but just in terms of the requirements of the racial impact statement pilot project, my sense is that we will probably have many situations in which we do not have sufficient data, simply because of sample sizes, to do some of the work that as Mr. Bam was talking about. And so I'm wondering, is there a requirement in the pilot project to look at other states where there have been, as Mr. Bam was talking about, where there have been examples of where we can look before and after, or when we can start to delve into the causality underneath some of the the cases and the things that are occurring. Is that in there? And I apologize, I just don't know the details on that.
Is that for me or?
I don't know.
So obviously, Mr. Baum did the statement, but the memo says that there are 5 questions that were to be looked at. What problem is the policy addressing? Is the problem addressing is the problem the legislation is addressing one that is worse or exacerbated for historically disadvantaged racial populations? What factors contribute to or compound racial inequities around this problem? More specifically, what policies, institutions, or actors have shaped these inequalities, disparities, and/or disparate impacts? And the final question is, if inequities are exacerbated, what actors at what levels of influence could reduce these inequities? It does say, the memo also says, when a conclusion is not feasible, the statement should describe the limitations or barriers which impeded concluding an impact, and whether relevant regional or national trends exist, which may provide helpful information. I think the key to remember is that this is just a pilot project, and presumably, if the council is interested in going forward and making this a permanent process, those considerations might be something that they think about in terms of how they direct racial impact statements in the future if they decide to go that route.
Great. And I just want to state for the record that one of the challenges that we will, I think, always have here in Maine is the fact that in many communities, marginalized and underrepresented groups have been systematically excluded from society in many ways, and in many cases have left Maine as a result. And I just want to state that for the record. So it does make these kinds of data collection efforts difficult, because when you have a situation of small sample sizes and only certain locations at which you can look at these kinds of issues, it does make that kind of conclusion drawing difficult. I do appreciate the qualitative questions that are in the racial impact pilot project, but I do think it's something we can hopefully provide some insight on as we go forward, as we kind of have some of these examples of the initial racial impact statements. So thanks.
Thank you so much. I do have Representative Sylvester, but the bill sponsor, Representative Parnett, is here as well. So I didn't know if Representative Parnett, if you had anything you wanted to add for the process.
Not specifically. Thank you for recognizing me, though. I simply wanted to be here to listen to the racial impact statement, which I had read, and would just point out that it recognizes that these agreements, non-disclosure agreements, do cause problems and harm in terms of employees asserting their rights and letting others know about practices that need to have the light of day shown upon them. So thank you.
Of course, thank you so much. Representative Sylvester.
Thank you. So first, I just say that if anybody has any comments about this procedure that they want to bring forward, we'll gather them and present them to the permanent commission. So feel free to send it to either of the chairs. But with that, I would make a motion ought to pass as amended with the original disposition of the original vote.
Thank you. Do I have a second? Seconded by Representative Gear. Any further discussion on this or anything? I want to thank everyone who's involved on this. Thank you for the process. I know this was just our first sort of step into this, and definitely committee members, we will be reminding everyone to make sure after adjournment we get all these notes. I know it's probably not going to be at the top of everyone's minds, but I think the committee feedback is absolutely invaluable for this pilot project. So please, if you have a moment while it's fresh in your mind this afternoon, please take the time to sort of jot down your thoughts on the memos. With that, Representative Sylvester, anything else, or ready to call the roll? Sounds good. Justin, if you wouldn't mind calling the roll.
And the motion was ought to pass. Is that correct?
As amended.
As amended. Okay, thank you. Okay, Senator Daughtry.
Yay.
Daughtry, yay. Senator Guerin.
Yay.
I'm sorry, what was that, Senator Guerin?
No.
No. Senator Guerin, no. Senator Hickman's absent. Representative Sylvester.
Yay.
Representative Sylvester, yay. Representative Bradstreet.
No.
Representative Bradstreet, no. Representative Cuddy.
Yes.
Representative Cuddy is yes. Representative Drinkwater is absent. Representative Gear.
Yes.
Representative Gear, yes. Representative Morris.
No.
Representative Morris is no. Representative Pebworth.
Yes.
Representative Pebworth, yes. Representative Prescott is absent. Representative Rader.
Yes.
Representative Rader is yes. Representative Warren?
Yes.
Representative Warren is yes. So we have 7 in favor, 3 opposed, and 3 absent.
Thank you.
Right.
Do you have a minority report?
Ought not to pass.
Not to pass. With that, the ought to pass is amended. Motion carries. And I will close the work session on LD 965. Thank you to everyone. That I do know, it's been a long day, folks. We're going to switch back to our language reviews. Mike and Steve, can you remind me which one we're picking up? I know we have 1724 to relook at. Additionally, I'm missing something else. I'm gonna phone a friend and page in Representative Sylvester.
Thank you. So the one that I said we weren't going to vote, we weren't going to reconsider because I thought it was a different, I thought we still had another department bill coming. And so I would make a motion. What number is that, Steve?
1925.
Okay.
Thank you. I would make a motion to, having voted in the majority, I would make a motion to reconsider 1925.
And is there a second? Seconded by Representative Warren. We're going to do a show of hands on this one. So if everyone can please turn on their cameras, please raise your hand and hold it up if you're willing to reconsider. It is unanimous of those present and voting. And with that, we will reopen LD 1925 and Representative Sylvester.
Thank you. I would make a motion to strip the ought to pass as amended, stripping the emergency clause.
I have a second. Seconded by Representative Warren. Any discussion on the motion? Seeing none, Justin, would you mind calling the roll, please?
So the motion has been moved to ought to pass without the amendment. Is that correct?
With the amendment stripping the emergency. And before we jump in, Representative Bradstreet.
Thank you, Madam Chair. Just for clarity's purpose, we're not doing just stripping the amendment. We're voting on the bill without the emergency. Is that correct?
Correct. Yeah.
Okay, thank you.
Do the rulemaking process. And a bunch of other things that Steve can answer if anyone has any questions on. Any further clarification? Seeing none. Okay, Justin, I think now we're officially ready to call the roll.
Senator Daughtry?
Yay.
Senator Daughtry, yay. Senator Guerin?
No.
Senator Guerin, no. Senator Hickman's absent. Representative Sylvester?
Yay.
Representative Sylvester, yay. Representative Bradstreet?
No, no.
Representative Bradstreet's no. Representative Cuddy?
Yes.
Representative Cuddy's yes. Representative Drinkwater's absent. Representative Deere?
Yes.
Representative Deere's yes. Representative Morris?
No.
Representative Morris is no. Representative Pepworth?
Yes.
Representative Pepworth, yes. Representative Prescott's absent. Representative Rader?
Yes.
Representative Rader's yes. Representative Warren?
Yes.
Representative Warren is yes. 7 in favor, 3 opposed, 3 absent.
With that, the minority report.
Not to pass.
Pass. With that,
So the way it works with rules is that a vote of ought not to pass technically authorizes them. So you might want to, you already have a minority report that says they can
Right.
authorize. You just want to stick with that.
Yes, I thought we did. Glad for reminding me. Thank you for reminding me. Yes, thanks.
okay. So with that, the majority ought to pass as amended carries. I will close the work session on LD 1925. I know we were going to bring up LD 1724. Any other ones floating out in the atmosphere that we're missing? I love the shrug from Mike. And Steve's looking. He's not seeing them up there. Representative Cuddy.
We had put 1724 off until after. We haven't finished 1724, correct?
Correct. So the question is, do we want to bring that up now? Has everyone had a chance to read the language? Do we need a few minutes? What is everyone's thoughts? A few minutes. Do we want to go into our caucus rooms just so we can review it and then hopefully get this done? Normally I kick the can and say we can bring it up on Monday, but we're running up against time. So Representative Bradstreet.
Thank you, Madam Chair. Yeah, on another bill, LD 2006, I received a fiscal note on it. It's $2 million, but I thought the amended version of it was $1 million. Maybe somebody could do some checking on it. I thought that was a compromise amount that we had.
I thought so too.
Okay. I'll look into that.
Okay. He'll check on the bill while we'll do our work, do our caucuses, and I will also go pour myself another cup of coffee. Justin, if you wouldn't mind putting us into your rooms, and folks will be back, let's say 5 minutes. Or Mike, got a question, or are you saying 5 minutes? You're on mute.
I was just throwing my hand up. We have this in our inboxes, Steve, right?
You do. I can also drop it in the chat if that would be helpful.
Well, we'll be in the caucus rooms. That's why I was going to ask you to do that, but I just wanted to make sure everybody had a copy of it.
Why don't we drop it in the chat right now? We'll wait to go in our breakout rooms until everyone's been able to click it open, and then we'll go from there. And then what do we think? 5, 10 minutes? Need more? Let's say 10 minutes for now, and we'll all just keep in touch and then circle back if anyone needs more time. And then any other questions while we're getting that in the chat? Everyone looks like it's a Friday right now, meant with an immense amount of respect and love. Okay, trying to get through. Wonder if I can, Steve, I can try sending it to you if it's giving you trouble.
Hold on.
I can say they say April is the cruelest month, but for me, March is because of the NCAA tournament.
But it's got Maine Maple Sunday too. And a few. Okay, we've got the bill right in the chat. So if everyone wants to bring that right up. And with that, Justin, if you wouldn't mind putting us in our breakout rooms, please. Okay, folks, for those following along and watching on the great YouTubes, we're just coming out of our caucuses. We're waiting for all of us to rejoin, and then we will be retaking up the language review on LD 1724 that we had previously held off on so that we could deal with our other presentation of the day. Representative Sylvester, do you mind shooting Representative Bradstreet text or Senator Guerin? Already on it, of course. Teamwork makes the dream work.
Is this a dream?
Feeling foggy enough for it to be a dream. I should say every day getting to serve in the legislature is a dream for all of us. Okay, folks, I think everyone's reassembling. Everyone take a big stretch. We're almost there. We're almost done. Okay, I think we have a quorum of us back. So let's kick things back off with the review of 1724. We had looked through the majority draft amendment. We had a couple of concerns about language matching up with the intent. And I know Representative Cuddy, if you'd like to jump in to verbalize our concerns.
I would love to do that. So in the amendment, Steve, right at the top, section 4, where it lists the 3 people who will be appointed to serve, B should have been basically the language that was in the sponsors amendment, where he draws from a list that will be provided by the AFL-CIO. Excuse me. But his language was more specific than what I just said, and it needs to come from there, from the sponsors amendment.
And of course, I muted myself. Representative Pebworth.
Thank you, Madam Chair. A quick question on page 3. It's under 3702(1) duties of the board. It talks about a harvester, singular, and forest landowners, plural. I think they should both be singular.
Yeah, those kinds of things I tend to leave up to the revisor's office, and that this has not been processed with them at this point. It was done, obviously, within the last day or two, but I usually leave those sorts of decisions up to them.
Sounds good. Representative Sylvester.
Thank you. I just wanted to hear from Mr. Daly that this is the amendment is the way he worked on it with Steve, and that this works for him since they are going to oversee this.
Thank you, Representative Sylvester and Senator Daughtry and members of the committee. Yeah, so as Representative Sylvester just referenced, Steve and I exchanged some drafts yesterday. And yes, this does generally reflect my understanding of how this might work if ultimately it's going to come under the BAC's jurisdiction. There's one clarification that I emailed with Steve about, and I assume he was in the process of adjusting it. But in paragraph 9 of the draft section 931-C, so basically the first statutory section, and then paragraph 9, in line A, striking 937 and just including section 931. But basically the gist of that section is to say that for the most part, the existing process for the BAC will be applied for the logging board should it come to fruition.
Okay. Does that clarify, Representative Sylvester?
Yes, indeed. And if I wasn't on mute, you would have heard me affirm that, but.
All good. Steve, do you need anything else from us? Okay. Anything else out there? I'm loving the like blank looks. Well, with that, I think we have actually finally concluded all of our work, except we do have another confirmation hearing due to the one that withdrew. Am I missing anything else, Steve?
I don't have anything. If I could just take this time to say, there will be obviously things still processing and that will require language review, but obviously the committee is not authorized to meet after this week. So unless I'm directed otherwise, I will send those electronically through email, and I will give you a time in which to respond. And if there are any issues, I will hold them and not report them out. If that is amenable to the committee.
Sounds good to me. I would say if you're having trouble tracking any of us down, since we'll be in session, sending paper copies to our desks to lock us down is always a good practice, because our emails, I think I speak for all of us when I say get a little swamped this crazy into the late part of the session. I do want to take this time to say thank you to everyone on the committee. Thanks for being so welcoming, for me coming in sort of mid-session, and it's been amazing to be a part of this team. And I know we'll have another time together with our confirmation hearing, but I did want to sort of ping for everyone. I'd love to see if we can find a time to get together as a committee. So I'll probably be sending out an email from Representative Sylvester and myself to see if we can gather. If anyone has any ideas, I'm always happy to host at the brewery as well. Just let me know. And I especially want to take a moment from all of us to thank Steve and Justin for all of their amazing and incredible work. We'll probably keep thanking you over and over again, especially all of the language reviews. But from the bottom of all of our hearts, seriously, thank you. You guys are a great team. We'd be lost, literally lost without you, probably in the waiting room of Zoom. And with that, Representative Sylvester, anything to add before we adjourn?
I would just say again, I think, looking today at our language reviews, some of the unanimous reports we've had, some of the really good substantive discussions that we've had in this committee go against what some of the folks say that the labor committee is just a straight 8-5 vote without, and I think, that I always appreciate being challenged by folks to make sure all the facts are correct and all, to see whether there's a compromise. And, I have enjoyed my time chairing this committee very much. And I appreciate all of your work, to make sure that we're taking care of the people of Maine and according to our own, the viewpoints of the folks who sent us here. So I just really want to thank you all, and I wish you all extremely well.
Absolutely. Hear, hear, and absolutely agreed. I don't know. Does anyone else have anything they'd like to share before we adjourn for the day?
Thank you all very much.
Thank you, Representative Brad.
It's been great serving with you all.
But it's been fun too. So I appreciate everybody here.
Absolutely. Well, we'll see each other in the chamber on Tuesday. And with that, everyone get out, enjoy your Friday. It's Maine Maple Sunday this weekend. So get out and enjoy this beautiful state we get to live in.